Hello, and thank you for coming in. My name is Ruane, and I'm a DUI defense attorney. Now that you're facing a DUI charge, your life is probably full of anxiety that you've never had before. Well, we are here to help. Over the course of the next 15 minutes or so, we will present you with a whole host of information that you need to know now that you are facing a DUI charge. But first, let me introduce to you the rest of the team members.
I'm attorney Jim Ruane. I'm a graduate of the University of Connecticut School of Law and the senior trial lawyer of the firm. My job, in addition to routine court appearances, is to coordinate the trial and motion practice of the firm. Since 1985, I have been certified as a criminal trial specialist by the National Board of Trial Advocacy, which qualifies me as an expert in DUI defense in Connecticut.
I'm attorney Teresa Donardi. I'm a graduate of Western New England College School of Law. I've been with the firm since 2006. My primary responsibilities are pretrial negotiation and jury selection. I am the primary contact with the Department of Motor Vehicles main office in Wethersfield.
I am Sean Barrett. I am a law student at Quinnipiac University School of Law. I have been with the firm since 2005. As the in-office investigative contact for clients, my role is to make sure your file is complete, obtain police reports and videotapes, and assist in trial exhibit preparation.
As for myself, I'm a graduate of the University of Connecticut School of Law, and I'm also the Connecticut State Delegate to the National College for DUI Defense. In addition, I am also field sobriety test certified as a student, just like the police officers, and I'm also certified by the United States Department of Transportation as an Intoxilizer 5000 maintenance technician and operator. These are the machines that you may have blown into in the police station.
One question many clients have is, how long will this case last? Many people believe that it will resolve on their first court date. That does not happen. This is because most of the time we are not finished investigating the law and factual issues in your case. You choose our firm to do everything possible in your defense. This takes time. A typical case requires anywhere from 3 to 7 court appearances over about 4 months. This may be extended if your case needs the extra time to get you the best disposition. We will work together over this time period to get you the best possible result, given the facts of your case and the type of disposition that best fits your life. If you elect for a trial, it may be up to 18 months before your case is completed. During that time, we are actively working on your defense.
Our firm operates on a total practice management theory. Instead of having one person in the office who you deal with, you can deal with any one of the members of our office at any time on your case. From the receptionist, to the paralegal, to the case managers, to the attorneys, every single member of our office is up to speed as to what is going on with your case at any one time. This way, you're not stuck waiting to speak to somebody in particular about your case. You can deal with anybody and get answers to the questions that you have right now. Eliminating the anxiety in your life is one of our main goals here at Ruane Attorneys. We understand that this anxiety can detract from your personal life, your professional life, and your ability to even sleep through the night. By retaining our firm, we put you in the best possible situation to remove these anxieties from your life and get on with the better parts of your life. When you're arrested in Connecticut for a DUI, you're actually facing 2 different types of cases. The first is the criminal case, and that is resolved at the courthouse, where you are innocent until proven guilty. The second is a civil case, and that is resolved at the Department of Motor Vehicles, where you are guilty until proven innocent. That's why it is so important for you to fight both aspects of the case. Both aspects can have repercussions on your driver's license, but the courthouse is the only place that can have repercussions on your permanent criminal record.
One thing people with DUI charges come to learn is that while you may feel like you are alone, many others you know have gone through a DUI case. However, simply because a friend or a family member may have had a DUI and have facts which sound similar to yours does not mean that your case will resolve the same way. Each courthouse has different prosecutors and different policies when it comes to DUI. Even when a case is in the same courthouse, many people have chosen to hire a jack-of-all-trades lawyer who may not have investigated every part of their case to find a way out. There was a mistake made on the night of your arrest, either by you or the officer. You cannot change what happened that night, but you can change how you deal with it.
Out on the scene, the officers may have subjected you to standardized field sobriety tests. Many times, people come into my office and say, "I don't know why I was even arrested. I did fine on those tests." What you must understand is that those tests operate on a concept of negative scoring. This means if you do 19 of the 20 things correctly on the test, you are not at plus 19, you are at minus 1. In essence, you start at 0 and can only lose points. Now that is a quintessentially unfair way of grading somebody. The police officers may have screwed up the administration of the test, but no one takes off points for them. In fact, many times, judges will allow that evidence in even if the police officer didn't do the test properly. Yet they hold it against you for failing to do it to their standards.
Because you took a chemical test with results over .08, the state has charged you under a per se theory of the crime. The elements for a per se DUI are: number 1, operating a motor vehicle; number 2, on a public highway; and number 3, with alcohol in your blood over .08 grams by weight.
Even though you took a chemical test with results over .08, the state will also charge you under a traditional common law theory of DUI. The elements for common law DUI are as follows. First, operating a motor vehicle; secondly, on a public highway; and thirdly, while under the influence. Under the influence in your case is defined as not having the caution characteristic of a sober person under the same or similar circumstances.
Okay, now here's the serious part. Whenever anybody is arrested for DUI as a first offense, as you are, you're facing a misdemeanor charge of DUI. A misdemeanor DUI carries with it the potential for up to 6 months in jail. But in all likelihood, that's not going to happen to you. In reality, a person who's charged with a DUI is facing a whole host of other, more serious ramifications than jail time. You can have a permanent criminal record for DUI that will travel with you the rest of your life. If you're convicted of DUI as a first offense, you'll be suffering a 1-year mandatory driver's license suspension from the DMV. Now that you're facing a DMV suspension of your driver's license, you need to know what the DMV is looking for to sustain their automatic suspension of your driver's license based merely on your arrest. You could be found innocent in a court of law and yet still lose your driver's license from the DMV. In essence, the DMV has to have 4 factors proven beyond a preponderance of the evidence for them to take away your driver's license. First, were you placed under arrest? Second, was there probable cause for your arrest? Third, did you take or refuse a breath test? And fourth, were you operating a motor vehicle? If those 4 things have been proven beyond a preponderance of the evidence, their automatic suspension of your driver's license will be upheld. Now, in order to combat this, we have hired from the DMV a former DMV hearing officer, Attorney Jim Olaus, who for years worked at the DMV and presided as a hearing officer and took away people's driver's licenses. Now he works for us, and he goes through your police report line by line to find a way to overturn that automatic suspension if any chance exists. Many people come in to see us after they've spoken with another attorney who has told them that there's no reason to fight the DMV automatic suspension. Well, we fight the DMV automatic suspension for 2 main reasons. First, if you do nothing, you lose. It's an automatic suspension based merely on your arrest. So by doing nothing, you guarantee yourself the result. You lose your license. And secondly, we fight because no matter how hard we fight, you can't get any worse penalty by fighting your case. The maximum penalty you can get is also the minimum penalty you get. There is no incentive not to fight at the DMV. And probably most importantly, by fighting at the DMV, we gather information that we can use to your benefit in your court case. One of the biggest concerns people have when they are facing an administrative driver's license revocation is, how am I going to get to work? Since this is your first offense and you took a breath test, you are eligible for a special operator's permit, provided that your driving history does not have too many moving violations. The special operator's permit is a permit which allows you to drive to and from work, as well as any work-related driving, for a maximum period of 12 hours per day. Your time period can run from 7 a.m. to 7 p.m., noon to midnight, whatever is most convenient for your work schedule. However, this is work-related driving only. You cannot drive to church or to school, and you can't drive to the doctor's or the supermarket. It is only work-related driving.
Once we open your file, we take a number of steps to begin your defense. We file an appearance on your behalf with the clerk of the court and the state's attorney so they know we will be fighting for you. Then we determine what evidence we need from the state and discovery. We obtain your police report and any available videotapes. We then contact the DMV and arrange for your DMV discovery and retrieve that from the main office in Wethersfield. We sit down with Attorney Jim Elias to review your report and look for issues which can be used in your DMV hearing. Finally, we review your file to make sure all the investigative issues are scheduled, like roadway photographs, witness interviews, and toxicological consults when appropriate in your case.
You must be aware that a DUI can have serious lifelong consequences, which is one of the reasons why we fight so hard for you. A DUI conviction can prevent you from international travel, destroy your credit history, increase your health and auto insurance premiums, or make you uninsurable, prevent you from obtaining student loans, cause you to be ineligible for certain professional licenses, lose your job, or even go to jail. Because the stakes are so high, we are committed to fighting this legal battle for you. This is our expertise. The impact of a DUI can create havoc in your personal life. If this occurs, we will guide you to the proper professional assistance because we are attorneys and not trained as social workers. We want you to have the best assistance in all the issues in your life. We handle your legal problems so you can address the other issues appropriately. Because you hired us, you no longer have to worry about the legal and administrative aspects of your case. We do that for you, and that allows you the time to focus on personal and professional matters.
At the courthouse, we negotiate with the prosecutor to get you the best disposition given the facts of your case. What may be a win for some people may be a loss for you. That is why we leave no stone unturned in negotiating for you the best possible pretrial negotiation of your case. If we can dispose of your case in a pretrial setting, you do not pay for anything else. You don't pay for a trial or any motions preparation. In essence, the legal fee that you pay for us at the beginning of your case is all that you will have to pay. One of the major concerns that people have when they come into our office is, how much is this going to cost me? Well, after we sit down and go over all the facts of your case, we will be able to quote to you your legal fee. One thing you have to realize, however, is that we do not charge on an hour-by-hour basis. Unlike most law firms who will charge you hourly and then take an awfully long time at the courthouse to resolve your case, we operate on a flat fee basis. That means that all of our pretrial court dates, all of our DMV court dates, all of the legal research and all the investigation is all covered for your single pretrial fee. If after all the negotiation you decide to elect to have a trial, there's an additional trial preparation and trial fee. However, in 98% of our cases, this fee is never an issue. We are able to successfully resolve most of our cases pre-trial. Because of that, we operate on a flat fee basis. This means you will pay one fee for however long it takes to resolve your case.
We want to thank you for taking your time to view this video. We know this is a stressful time for you.
In a few moments, one of us will be in to speak with you and take as much time as necessary to answer all your questions.
Here at Ruane Attorneys, we are committed to providing the best DUI defense in Connecticut. That starts now.